Number 84, Deutsche Bank National Trust Company v. Morgan Stanley Capital Holdings.
May it please the Court, Brian Weinstein from Davis Polk for defendants appellants Morgan Stanley Mortgage Capital Holdings and Morgan Stanley ABS Capital One. I'd like to reserve 2 minutes for rebuttal, if I may.
Yes, sir.
Thank you, Your Honor. This is the third time in the past several years in which this Court is addressing efforts to avoid the sole remedy provision in an RMBS contract. In both of the prior two cases, Nomura and Ambac, this Court held that you can't avoid the sole remedy provision by alleging pervasive loan-level breaches.
Counsel, just to be clear, I just want to make sure I understand at least one of your arguments, that they cannot assert this gross negligence claim unless they can establish an independent duty.
That is correct, Your Honor, and I will certainly get to that point. But
why isn't there, I may move you along there, why isn't there an independent duty given the SEC regulation of this particular area and given the tremendous public interest in what goes on with this kind of securitization?
Your Honor, the issue on the SEC order, and that's the only thing that in any way is different than the standard RMBS case in which there are allegations of pervasive loan-level breaches. That issue is a disclosure issue in the offering documents to investors involving approximately 3% of the loans in the trust.
Am I also right that, I'm sorry, over here, am I also right that the complaint doesn't plead that as a breach of, a grossly negligent breach?
I believe that's correct, Your Honor. They do allege it as a basis for punitive damages, which we obviously don't think is the case. But the answer to Judge Rivera's question is that that breach of duty, if there was a breach of duty, would be a breach of duty to the investors, not to the trustee. And the investors, as this Court is aware, have brought a whole separate class of cases for those types of issues, disclosure issues in an
So there are no promises, warranties, guarantees at all made with respect to the relationship with the trust. Is that your position? All of those representations go right past the trust and the trustee directly to certificate holders.
The disclosure issues do, Your Honor. The way in which there is some commonality, and this actually supports our point, is that one of the breaches that they allege relating to these 3% of the loans is that one of the representations and warranties in the contracts with the trustee is that the loans are not in default. So with respect to those loans, they can bring a breach of contract action, and that involves 3% of the loans. But that's still a breach of contract claim. It's not the breach of an independent duty. With respect to the issues in the SEC order, that's a disclosure issue relating to the offering materials.
There are no representations, warranties, guarantees, promises that are in any way intended to address any regulatory requirements?
That's not, even if there were, Your Honor, I don't know whether there might be one that's construed that way. That's not one of the allegations that they've made here. The point is that would still be a breach of contract. They haven't alleged any breach of duty.
No, but my point was whether or not this federal regulatory framework somehow, assuming I agree with this argument that you're making, that you must have a separate independent duty to be able to argue gross negligence as a cause of action.
Yeah, well, our argument, Your Honor, is there needs to be a breach of duty that goes outside of the breach of the actual representations in the contract.
Mm-hmm. Counselor, aren't there two different ways we can approach the issue here? One being whether, in order to establish this gross negligence public policy exception, the provision, the contractual provision in question, has to either exempt liability at all, or limit it to a nominal sum, or whether that is the case. That's one way to look at it. So in other words, if that's the case, then we might say that there's no cause of action here because the sole remedies provision was intended to make the trustee whole. So that's one way to approach it. Another way to approach it to get to your result is to say they didn't actually sufficiently plead a gross negligence cause of action.
That's exactly.
For a number of reasons, right?
That's exactly correct, Your
Okay,
Honor.
so why should we take one approach or the other?
Well, either one of those approaches means that the court should rule in our favor, Your Honor, and that's the point I was trying to lead with, which is that the fundamental key point, just to start out here, and why this court should not reach a different result than it reached in
Well,
November.
there is a difference, though, in Judge Stein's question, because in one, we'd be saying that it is possible for there to be a type of negligence that can arise from a contract action, and another, we're saying that your damages, that a limitation of remedies is allowable, and even though it may not make you fully whole, and it represents a significant policy switch. And I'm asking, I think if I follow up on a question is, where do you come down on either side of those policy questions?
So I'm not certain I understand the question precisely.
You have
Let me try to.
gross negligence and damages that can arise from there. That can be enormous.
Correct.
Then you have damages, a limitation on liabilities, contractual damages, which are limited to the cure and repurchase provision as much as applicable. Those are much more limited. It's a significant policy and financial difference.
The fundamental point here, Your Honor, is that this case.
No, that's not, I understand the fundamental points, sort of. But what I'm concerned about is where do you come down? What are you advocating for?
And I apologize, Judge Fahey, I'm not sure that I understand that.
Are you advocating for the cure repurchase provision is, you're limited to that and the limitation of liability applies? Or are you saying that even though we may win on the gross negligence because there's not an independent basis in tort?
I'm sorry, I understand now, Judge Fahey, and absolutely we are arguing that the limitation applies, and the reason is it provides a full remedy with respect to any breaching
That's
loan.
what I wonder, see, because I had thought that you were conceding for the purposes of this case, and that it's the law of the case, that plaintiff can obtain damages in lieu of specific performance if specific performance is impossible for the loans that have been liquidated. In other words, you wouldn't have any chance at some future point to really litigate whether those damages through specific performance and its failure is impossible.
Yes,
Is
Your
that
Honor.
right?
That is right. With
All right,
respect to
so you're conceding that they can receive damages if they're eligible for them through equity if there's a failure of specific performance.
that is the governing law in the First Department now, Your Honor.
In this case?
In this case.
Right, I see.
So that position is that the appellate division was incorrect to argue that the sole remedy provision provides an illusory remedy.
That's
Right?
exactly
That's
right.
where you are on that. But why wasn't the appellate division correct to say, well, it's premature for us to determine that?
So the reason that it's not premature, Your Honor, it's obviously one of the key principles of New York contract law is the importance of predictability and certainty. And so it's important that litigants not have to wait until the end of a litigation to know whether or not the contractual remedy provisions are going to be enforced unless there's a good reason to doubt it. And here, there hasn't been any reason articulated why, with respect to every breach that they can prove, they're not made fully whole. The repurchase remedy is nothing even remotely like limiting them to $250. It makes them whole for every breach they can prove. We have to repurchase the loan at full price plus interest.
They say you refused to repurchase some of those loans.
Well, because we dispute that there are breaches, Your Honor. But the point is, for any breach that they can prove, they are made whole.
Okay.
And that's why the public policy exception does not apply. The public policy exception says you can't immunize yourself from liability based on your own gross negligence, and that's simply not what the sole remedy provision does. The sole remedy provision says every breach you prove, we have to buy the loan back. And
Your
there's
point is
nothing-
you're not trying to change that. What you're simply saying is it doesn't apply here.
Correct, it doesn't apply
Let me
here
ask one
because-
question. It's just a little bit outside of what we've been talking about. Was there ever a motion to dismiss based on the statute of limitations ever brought in this case by you as a party?
There is a pending motion for summary judgment, Your Honor, on that issue, which has not been adjudicated yet.
I see.
But the fundamental issue here, Your Honor, is they haven't identified a single way in which for any breaching loan that they identify that they're not made whole. What they're really complaining about here is the burden of complying with the condition precedent in this contract of having to prove the breaches loan by loan.
And to be clear, sorry, over here again, the damages available through the repurchase provision are contractual, not in equity. Is that right?
That's correct, Your Honor. It's a contractual remedy that makes them whole. It requires that the repurchase price be paid for any breaching loan, which is a full remedy. In other words, the full unpaid principal balance plus interest. So they're made whole. And the point is, Your Honor, is really what they're objecting to, because there's no damages for any breaching loan that the sole remedy is depriving them of that they're otherwise entitled to under the law. They get the same repurchase price if the loan's been liquidated. They complain that what about rescission, but their rescission wouldn't be available to them irrespective of the sole remedy provision, and they get made whole. So what is it that
Does that mean they're entitled to attorney's fees? Otherwise, they've lost out on that.
Well, attorney's fees is a whole separate issue.
I understand, but isn't it in
The
reality
repurchase price-
interconnected and you can't escape that?
The repurchase price is where the definition, is where the provision for attorney's fees comes in.
Okay.
But the point is, so what is it that they're objecting to? They're objecting to having to meet the condition precedent of proving their case loan by loan. And that's not a basis under the public policy exception for rewriting the parties'
Are they able
contract.
to do sampling?
I'm sorry?
Are they able to do it by sampling?
No, well, Your Honor, that's the issue. That's what they want to do. And there's a separate appeal that's going to be
Okay.
pending before the court on sampling. But our point is, this is
Why
like-
doesn't that mean perhaps it's premature?
No, Your Honor, our
If
point
that
is...
doesn't work out in their favor, and they're back to what you've just said, which is they've got to go one loan at a time.
Correct. So if they are not allowed to sample, then, and the contract, and they have to do what the contract says, which is to go one loan at a time, that's what they're saying could invoke the public policy exception that allows this contract between sophisticated parties to be rewritten by the court. And we would submit...
You can
there's-
see if they're going one loan at a time, that could be 2 decades worth of litigation
No,
at a
Your Honor,
minimum. We're not counting the appeals.
So two points to that, Your Honor. The main point is, in the AHA case
Yeah.
decided by this court, the court drew a sharp distinction between conditions precedent on the one hand and exculpatory provisions on another hand. What they're objecting to is having to comply with a burdensome condition precedent of having to go loan by loan. That's not a basis for nullifying the sole remedy. As to your question, Judge Rivera, it is a burdensome process of going loan by loan, but that's not a basis for rewriting the party's contract. There's no precedent for that. There's no precedent for saying...
But when they entered this agreement, do you think anyone, well,
No.
who would enter an agreement if they thought they'd have to go loan by loan for 95% of the loans?
Your Honor, both in Nomura and in Ambach, this case was clear that there's nothing in the contract that says above a certain threshold of breaches, the sole remedy provision just
Yeah, but the whole
falls
thing
away.
breaks down because no one will buy into this, right? No certificate holder would
Your
buy
Honor,
a
there's-
certificate, you lose the REMIC status. I mean, the reality is, everyone is working on the assumption, apparently without doing appropriate due diligence, but that's a different case, that there weren't going to be these massive breaches that lead to the loan by loan, hundreds, if not thousands of these loans that you'd have to do one at a time to go through the breach.
Your Honor, again, I believe that's the issue.
I mean, it seems workable if you're only, I mean, I'm not going to disagree with you. It seems quite workable if you're talking about 1% of the loans or spreading that out over time. But if you're really talking about, as they say, this kind of massive breach, I know it's allegations, I appreciate your position on that, but even 3% is not a small amount.
You're right, it's not a small number, Your Honor. I don't dispute that there is a burden of complying with this condition precedent.
Yeah.
The point is, that you can't say that because a condition precedent is burdensome,
Okay.
under the guise of the public policy exception, we're going to rewrite this contract between sophisticated parties.
Fair
Yeah.
enough. Thank you, counsel. Please go ahead.
Good afternoon. I'm Stephen Mollo. I'm here with my partner, Justin Ellis. Thank you
Counsel,
for...
can you identify for us any situations, other situations where we have looked not to the formation of the contract and what the contract says and the intent of the parties, but to its practical effect maybe years down the road when, this kind of situation arises? Can you identify any precedent for doing that?
So in this context with the gross negligence exception that we're invoking here, or the policy, that we're invoking here, the issue arises during the course of the performance of the contract, not in the formation of the contract, of course. And my colleague here, Mr. Weinstein, is absolutely right. There is a strong policy in New York that favors the idea that sophisticated parties can come together and decide how they want to conduct their business, and the courts are going to interpret that very closely, okay, and strictly adhere to it.
So the question is, how do we interpret that? Do we interpret that as of the time of the formation of the contract, or do we look to what are the practical effects of it down the road? I mean, wouldn't that create terrible uncertainty if we did the latter?
It would be at both points in time, but there is an equally strong, in fact, a greater policy interest that the state of New York has in ensuring that commercial activity is conducted honestly. So parties are not allowed to insulate themselves.
Let me ask this. And I wonder this, honestly, in a lot of the RMBS cases that we've seen, why isn't there a tort claim for fraud brought in the complaint here?
I think in most instances, the reason that there isn't a tort claim brought is because there is a clear contract claim.
Well, okay,
and it's a simpler thing to prove the contract claim.
But you're saying here that there isn't. If I'm right, you know the timeline better than me, but you got a 2007 closing date. The forensic examination of these 800 properties took place in 2011, the 800 loan sample. We don't see a summons with notice until 2014, 7 years after the closing date, and we don't see a summons and complaint till a year after that, 8 years after the closing date. So why wasn't there a tort claim for fraud? Wouldn't that make your case a stronger case when you're arguing for an independent tort basis for a gross negligence claim?
Well, we don't have to bring a tort claim.
Well,
there's a clear contract claim.
And what am I missing? Sometimes I feel like there's shadows on the wall and things are happening behind me, and I'm not quite clear why this isn't in front of us, since this seems at the core of the argument that you're making.
It's not the core of the argument we're making.
All right, why wasn't, answer my first question. Is there a legal or policy reason why, that you know of, a fraud claim wasn't brought? Okay.
If I may.
Sure.
Sure. So the policy, okay, does not require to invoke gross negligence and to have the policy say that the parties are not allowed to insulate themselves from liability. We must plead and then later demonstrate. I want to just remind the court, we're at the pleading stage here.
Right, I understand.
To your point, Judge, this is not, that's a whole nother issue too, because when we get to issues of damages, this court's decision in Sokoloff says you deal with that later in the case. It's not appropriate to deal with on a motion to dismiss. But we must plead and prove that the conduct smacks of intentional wrongdoing and evinces a reckless indifference to the rights of others. There's no requirement that we plead an actual tort claim separate and apart from the contract claim to invoke this exception. All we must show is that the conduct smacks of intentional wrongdoing and it evinces reckless indifference to the rights of others. And when you look at it,
But gross negligence is a tort concept, is it not?
it is a tort concept, and it's an importation of this tort concept on the contract claim. The restatement does a nice job of explaining this, and it's at restatement 8 in the intro to the note. There, it says that the reason that courts don't enforce contract provisions that in the face of this kind of conduct that smacks of intentional wrongdoing and evidences a reckless indifference, there's two predominant reasons. One, enforcement of the limitation, this damages limitation, remedies limitation, would be an inappropriate use of judicial resources to allow a wrongdoer to proceed with what they call an unsavory transaction.
Here, let me take a step back for a second.
Sure.
Let's start with the assumption that you did plead an independent tort. You pled negligence.
Okay.
All right. Negligence, you didn't act as a reasonable man, there's ordinary negligence, and you're saying, no, we're not claiming ordinary negligence. We plead the tort of negligence, and the standard by which it should be evaluated is gross negligence, willful misconduct, assuming that you pled that. All right? I think you can make a legitimate argument for that. Do you understand what I'm saying?
Yes.
Yeah, it is an independent tort. Of course it is. Negligence is an independent tort. The question is the policy question here is when do we reach it? That's a separate question. My question to you was, why didn't you plead fraud?
Why didn't we plead
Yes,
fraud?
yeah, particularly after the forensic examination.
I'm sorry, it's just,
It's all right, particularly after the forensic examination in 2011.
well, I mean, because fraud obviously has additional requirements.
Right.
Of proof beyond a contract claim, right? And, you know, we do allege and we seek punitive damages, which does require, now punitive damages on a contract claim
Right.
does require some form of pleading and proof of an independent tortious act. And we do allege that we've met that standard again at the early stage of the case in terms of setting forth that claim. And, you know,
What was the act that you pled then? What was the tortious act you pled?
it was fraudulent conduct. They admitted, or they entered into an agreement with the SEC.
Did you plead the elements of a fraud cause of action?
The allegations in the complaint
Yeah, that's.
make out, we don't actually have a count for fraud in the complaint. We seek punitive damages on the contract claim. New York law says that for us to be able to get the punitive damages on the contract claim, we've got to have some kind of tortious act beyond the mere breach of the contract.
So that's what I'm asking. So the tortious act is fraud? Is that
Correct.
what you're saying?
Correct.
Okay, But,
In the form,
but you're calling it a tortious act of fraud. Doesn't that mean that you have to allege the elements of a fraudulent cause of action? I'm just talking about the punitive damages.
no, it's not
No, you
required.
can
The
just
case,
say it was fraud, they misled us. That's enough.
yes.
That's
The
enough.
case, the case law, the NYU case.
Counselor, the problem there is you're equating fraud with negligence. You see what I'm saying logically?
It isn't, Your Honor, and let me explain why. Let me explain why.
Go ahead.
Okay? You have a concept in contract law that says that if parties enter into an agreement, and that agreement has a provision that allows them, either of them, I guess, to insulate themselves from liability in some way, all right? It doesn't matter if it's liquidated damages. It doesn't matter whether they're 100%, it doesn't matter whether it's nominal damages or it's, they're 100% insulated. And your cases, by the way, do not draw that kind of distinction. But just from a policy standpoint, okay, the law says, and this is where, again, I go back to where the restatement says, that if, in fact, in performing the contract, the parties engage in something that is smacks of intentional wrongdoing, evinces a reckless indifference to the rights of others, they're not entitled to that protection, even though they contracted for it, even though they had lawyers, even though they laid it down in, you know, thousands of pages of documents. It doesn't matter because at that point it goes beyond. It's beyond just those parties.
I'm sorry. So why isn't the remedy, let's get now to the point that he was making before. Why isn't the remedy that was negotiated enough to compensate you for the kind of harm you're saying occurred?
So, Your Honor, it's not enough for several reasons.
Okay.
First of all, once we get into the land of them engaging this conduct, their protections, their limitations go away, right? And the clause that they're seeking to enforce is called the sole remedies clause. By its name.
Yes, but if the sole remedies clause gives you full and complete recovery.
No, it doesn't.
I'm saying if it does,
Okay.
then the fact that it's called the sole remedies clause, it doesn't make a difference, does it? And let me just take this one step further. Talking about certainty of result in contracts, doesn't it lead to terrible uncertainty if in order to determine whether to apply this public policy exception, you can look to any limitation regardless of how small that limitation is and say that's enough because you're limiting the remedies, even if it's just a little bit less than you think you otherwise might be entitled to get.
Well, again, we go back to why should a party, and this is the policy of the state, it's the policy across the country, it's the policy set forth in the restatement. Why should a party be able to insulate itself from liability?
I'm not talking about insulating from liability. I'm saying you choose what the measure of your damages will be.
Right.
Okay? And It may be a little more or less than what they otherwise might be, but they don't insulate the other party from damages. That's the question here. We know we have cases that talk about exempting from liability. That's a total exemption. It doesn't matter what I do, you don't get any recovery. Then there's providing a nominal sum, and whatever that may be. And clearly, there are cases that it said, $250 when the claim is for $1 million, that's a nominal sum. Now, I think, if I understand you, you're trying to expand that so that any time there is an agreement in a intelligently negotiated contract that doesn't leave all possible damages open to you, that provides an opportunity to come in and say, you were grossly negligent, and therefore all bets are off. Why does that make sense?
It makes sense for two reasons. First, we're held to a pleading standard here, right? We just can't, this isn't going to mean that every party to a contract can come in and make that allegation. We've made allegations at this stage that support us going forward on that point.
So you don't concede,
Secondly,
hold on one second. You
okay.
do not concede that this provides more than nominal damages? That this contract provides, this provision, sole remedies provision, provides more than nominal damages?
It does. I'd like to address, can I answer the question? Because I do want to answer your question. The second point, okay? This court's decision in Abacus said that exculpatory clauses, now there was an issue of only nominal damages there in Abacus, but the holding of the court says that exculpatory clauses and liquidated damages clauses are not enforceable against allegations of gross negligence. Liquidated damages, by law, are supposed to approximate the actual damages that a party would experience. The law professors that they recruited, who I would give an F to their brief, but the law professors even said that you have to at least approximate what the actual damage would be. So that means that it's not nominal.
Why isn't it enough? You were there and you didn't get a chance to answer it. Your light is on. I want to give you the opportunity to answer it. Why isn't the sole remedy clause enough?
The reason the sole remedies clause is not enough here is that we have a question, an open question about whether and to what extent we can recover for liquidated loans. Now, the law in the First Department is that we can, but this court has not ruled on that question yet. There's an open question about whether we can use sampling, and the courts are split on that. There is a question about whether, as Your Honor noted, a loan-by-loan review in these circumstances would be so time-consuming and so burdensome that it effectively limits our relief. And we are relatively early in the stage of the proceedings. Damages are issues that are addressed, is an issue that's addressed late in the case. And we don't know what arguments the defendants are going to make when we get to that damages issue and how they might try to say that we're limited from somehow receiving our full recovery.
Your red light is on, so let me just give you a moment, really a moment,
Sure.
to address the punitives. How indeed was the trust injured as opposed to the certificate holders?
And I'm so sorry, but with the masks, I just didn't quite understand the question.
I'm sorry, I wanted you to have an opportunity to address punitive damages, but your red light is on.
Oh, sure.
And it appears
Sure.
Judge Wilson has a question. We want to give him an opportunity
Sure.
to ask that too.
Can I finish the sentence that I was saying on that last point too?
Very quickly.
Okay, just briefly. This court noted, as I mentioned in the Sokoloff case, we shouldn't be precluded now from being able to pursue this issue of the policy exception to the limitations clause. That's something for later in the case and something that we're still going to be held accountable to the proof on. On the question of punitive damages, the NYU case sets forth the four-part test. We've met the first part, and that is actionable in tort as fraud, as we mentioned before. The facts that are alleged are extrinsic to the contract. The existing status of the trust, how many people were in default. The conduct did address the trustee specifically, And the representations about the delinquency rates were made to the certificate holders.
Well, that was my question about the trustee. I was
Right.
targeting the trustee,
So-
as opposed
so-
to certificate holders or someone else.
The same representations were made to certificate holders in the offering documents as were made to the trustee in the representations and warranties. In response to the question about was there any representation concerning having met all legal requirements, there was an allegation in the complaint. If you go to the appendix A55, paragraph 25 of the complaint, it mentions some of the specific representations and warranties made to the trustee, including that the information on the mortgage schedule delivered to the trustee was complete, true, and correct, that any and all requirements of any federal, state, or local law had been complied with, that there was no fraud, error, omission, negligence, or similar occurrence with respect to the mortgage loan. I can go on, but the points were made. And also that there was no default, breach, violation, or event which would permit the acceleration existing under the mortgage or mortgage
Thank you,
note.
counsel. I believe Judge Wilson has a question.
Yeah, so the only place in your complaint that I see gross negligence alleged is paragraph 82. Otherwise, it simply reads as negligence to me. You can correct me if I'm wrong. Paragraph 82 says, on information and belief, MSMCH and MSAC were grossly negligent in failing to identify and cure breaches of their representations and warranties. I don't see any allegation in the complaint that the representations and warranties were made with gross negligence. And so the way I read your complaint as to gross negligence is to say they were grossly negligent in failing to perform their contractual duties. That's a strange concept because we allow people intentionally to breach their contract and pay contract damages, and we think of that in some cases as efficient breach. So you seem to be asking for a very strange expansion of the law of contract.
Now, it would not at all. You go back to Abacus, and Abacus says the only time we get to invoke this is when the conduct smacks of intentional wrongdoing or evinces a reckless indifference to the rights of others. So you could have a situation where there might even be an intentional breach by someone that's done for an economic self-interest that doesn't necessarily rise to the level of smacking of intentional wrongdoing, having that kind of moral culpability that the law should not facilitate and courts should not facilitate by enforcing these limitations of liability and limitations of remedy, really, clauses. And you certainly should not do it at the outset of the case, which is what happened here. We should at least be allowed, we've pled it. They paid $300 million to the SEC based upon their conduct in this case, which found them to be deceitful.
What is the moral culpability here?
What is their culpability, moral culpability?
Yep.
How about the SEC having said that they engaged in deceitful conduct, and as a result of the SEC investigation, they understated, well, one of the things revealed in the SEC under investigation, they understated the loans that were then in default at the time that the deal was coming together by a factor of 4. They reported 1/4 of the defaulting loans, and that's a significant factor, as the SEC found, as to whether or not a mortgage loan will perform and whether or not the transaction will succeed if you have a large number of non-performing loans, because early on these defaults were occurring.
Anytime there's a fraud on a wide scale, that's enough to get you punitive damages?
Absolutely, because when we come to the factor of punitive damages and the broader effect,
I'm not just limiting it to this scenario of the RMBS transactions. I'm saying out there in the world, anytime somebody commits a fraud which is widespread, that entitles the plaintiff to punitive damage.
if it's so widespread that a pre-filing investigation in this case, a survey of 800 loans found that 100% of them breached the representations and warranties. A situation where $495 million were the losses at the time that we filed the complaint, they're much greater now. A situation in which they paid their primary regulator $300 million to resolve this transaction, to resolve the investigation on this transaction, which was a $1 billion transaction. A situation in which they paid $2.6 billion to the Department of Justice based upon their 250 RMBS transactions, this being one of them included in that, which contributed to the extraordinary financial crisis that this state felt the brunt of greater than any other part of the world.
So is that?
So yes, in that
so,
circumstance,
counsel,
we're entitled to punitive damages.
Counsel, is that perhaps a bit of a difference, that it's not just that it's widespread, it's that the consequences were so dramatic and significant for so many people, not just the certificate holders, because of the nature of the securities?
Certainly in this case, yes, absolutely yes. In this situation, the conduct of the defendant had far-reaching consequences on the public, and far greater than the consequences of the situation where a fire alarm, I don't mean to diminish that, may not have been working, and the court said that, you know, that's something that has a broader consequence in the context of the gross negligence being applied just for the public policy exception to limit the limitation of liability clause. But in the punitive damages consequence, this is precisely the kind of case for which the punitive damages, the general exception to the rule that punitive damages are not allowed in contract cases, applies.
Thank you,
The
counsel.
only-
Go ahead, yes.
Judge Rivera, did you want to say anything about the attorney's fees issue?
About attorney's fees?
Yeah.
We would like them. And the Court of Appeal, the First Department said that we're entitled to them. The basic point that we make is that...
Well, if in other parts of the agreement it mentions attorney's fees and doesn't here, why should attorney's fees be encompassed?
Because,
under that provision?
Because we're entitled to our costs for enforcing the repurchase remedy that gets built into what's called the repurchase price.
Okay.
The repurchase price and our enforcement of the repurchase remedy is all about legal fees. It's all about legal action. The only action that occurs outside of that is some very ministerial mailing of notices of breach.
But if it's so consequential, and
Absolutely
really,
it's
and
consequential.
as you say, really the cost associated, why not use those two words if it's used elsewhere?
Well, you know,
Seems a bit
the Breed-Abbott case that we cite in our brief is a good example of why you don't have to do that, because the parties just understand that that's going to be part of it. In the Breed-Abbott case, there was a question about indemnification, and the word in the clause that related to indemnification didn't actually include the term attorney's fees as part of the indemnification. And this court concluded that it would make no sense to not include attorney's fees just because they weren't mentioned. So when you use the term enforcement, and we cite several cases in our brief to this point, enforcement implies a legal action, the enforcement of the rights, and that is what the action is here. So for that simple reason, we're entitled to fees, and the First Department found as much.
Thank you, sir.
Thank you very much.
Yes,
I'd like
thank
to start by addressing Judge Fahey's question, which I think is very illuminating, which is why didn't they bring a tort claim here or a fraud claim here? And Your Honors, there have been scores of these RMBS trustee cases brought, as you're well aware, by many of the finest law firms in the world. Not a single one of them has brought a tort case by the trustee. Not a single one has sought punitives except for this one. And the reason is very clear, which is that there is no tort against the trustee. To the extent there is a tort alleged based on these allegations, it would be against certificate holders. And in fact, the certificate holders did bring fraud claims and did bring securities claims. And if there was going to be a punitive damages award of any kind, even in the picture, you could have a debate about whether it should be merited in the certificate holder cases, but it would have to be brought on behalf of the certificate holders. The relationship with the trustee is purely a contractual relationship, Your Honors, and that's why they haven't brought fraud or tort claims.
But why would they have would they associate themselves with representations that are fraudulent? Aren't they also depending on the veracity of the representations? I mean, it's their reputation on the line also, is
They
it not?
simply have no tort claim, and that's why none of them have brought it. The relationship between the bank and the trustee is purely a contractual one. And in that contractual relationship, for any breach they can show, they're given a complete remedy. There is no tort claim vis-à-vis the trustee. There's no representations collateral to the contract, which is another reason why they just couldn't bring a tort claim. If there's any...
Is that, am I misunderstanding, I may be misunderstanding the argument. Is that just another way of saying they don't care whatever the alleged fraud is, because only the certificate holders really end up suffering a consequence from that?
That's absolutely right. As has been discussed in many arguments before to this court, the trustee has no financial, dog in the fight, so to speak.
Okay.
The money gets passed through to the certificate holders. And so that's why, and I'm glad that Mr. Moeller brought up the restatement, because it makes our point precisely. What the restatement says is that a term exempting a party from tort liability for harm caused intentionally or recklessly is unenforceable on grounds of public policy.
What section are you reading, sir?
That's Restatement of Contracts, Section 195, Restatement
195.
Second. And
Thank
that's precisely what this court has cited, along with some other contract treatises, when it described what this public policy exception is in all of its cases. And that's precisely right. And it stands to reason, as Judge Wilson said, even an intentional breach of contract, and this was the court's decision in Metropolitan Life, even an intentional breach of contract for the party's own financial gain doesn't nullify a sole remedy provision or a limitation on remedies. That doesn't give rise to the type of gross negligence that you need. And that stands to reason, Your Honor, is because a limitation on remedies in a contract already assumes that there is a breach of contract. And so you have to have something besides a breach of contract. You have to have some kind of other breach of duty from outside the contract in order to invoke the public policy exception.
But if you do, then if it was an intentional breach is not a factor in the equation, correct?
Well, if you have an independent tort that you can claim,
Right.
and you have a provision that is immunizing the defendant from liability, that's when the public policy
So I'm just saying
exception-
that comparison to the intentional action sort of falls away and is not really relevant, given what you yourself say is the state of the law, what the rule is. If you've got an independent basis for a standard of a duty of care, doesn't matter if it was intentional, if there's also gross negligence, they can proceed with their claim.
If there is a separate basis outside the
Yes,
contract to say
correct. Yes.
that the defendant is guilty of a tort or something akin to a tort, some kind of breach of a duty outside the black and white terms of the contract, and if the limitation on remedies immunizes the defendant from liability, that's precisely when the public policy exception comes in. And the problem with plaintiff's argument here, again, Your Honor, there's two fundamental aspects of it. The first is that the defendants are not immunized from liability, and the remedy is a full remedy for every breach that they can show. And they haven't identified any basis to say that they get less than a full remedy for any breach that they identify. What they're objecting to is the burden of having to go loan by loan to meet the condition precedent. And this court was clear in AHA that a condition precedent is entirely distinct from a provision that immunizes a party from liability. For every breach that they actually prove, they are made whole, and they haven't indicated one basis for saying that that's not the case, other than liquidated damages, which again, under the current law, we've conceded they're entitled to liquidated loans, I should say. They're entitled to the repurchase price under the First Department law, whether the loan's been liquidated or not. So it makes them completely whole, and they haven't alleged any breach of duty outside of the contract. And that's both why the gross negligence arguments fail, and it's also why the punitive damages arguments fail, because they haven't alleged any breach of a duty outside the contract. Again, that's why in the scores of other RMBS trustee lawsuits, no other trustee has even sought punitive damages.
Okay, your light is on. Do you want to quickly address this question about the attorney's fees?
I would, Your Honor. Briefly, as you said, Judge Rivera, the relevant provision here does not refer to attorney's fees. It refers to costs and expenses. 17 other places in the contract do refer explicitly to shifting attorney's fees This court set a very high bar for departing from the American rule on attorney's fees in the Hooper Associates case. That high bar is not met here when the contract is read as a whole.
Thank you both.
Thank you, Your Honors.